Welcome back, landlords. So today we're talking about the eviction filing process. Specifically, how long does the process take? So one really good thing about the eviction statute is that it is so narrowly tailored that the court gives it a kind of special status. Now, that also means that the topics are limited. The substance of an eviction filing is limited to the demand for possession, and if there is an award of rent, whether or not an amount of rent remains unpaid. And that's it. I mean, that's essentially it. And so the court's going to hear information about the validity of the demand for possession, and then the validity of an outstanding balance for rent. And so, how long does this process take? Well, by statute, the eviction is typically limited to 21 days. Now, the process in practice ends up taking a little bit longer depending on what the participants do. So naturally, if you have some kind of error in your filing and you have to refile something or amend your petition, I've even had to do that once or twice. It's going to extend time, but not usually more than a week or so, especially if you catch whatever error you've committed, if you catch it early. And so there's that. But generally speaking, it takes 21 days for you to get to trial. Sometimes it's a little sooner, and it depends entirely on the court. But the statute does require that it happen basically within 21 days. Could it be extended? Yes. So the kinds of things that pop up are emergencies. If it turns out that the defendant has a legitimate emergency, the court can, as you know, in the interest of justice, give some extension, not months, generally a few days, maybe a week. You also could have some issue that creates the need for a continuance. And so if that happens, the court does have the authority to extend the process. But let's say none of that happens, and you're on day 21 and you're set for trial, and you attend the trial. Well, does that mean that the whole thing is over once you've proven your case? It doesn't. Remember that every eviction, every case actually that's heard in the justice court that goes to judgment is given an opportunity to appeal. And so with regard to the justice court, typically you've got 5 days before you can get 5 days for the defendant to file an appeal. Depending on the interpretation of the rule and depending on when the 5th day lands, in practice, that sometimes comes out to 7 days. Sometimes with a holiday, it goes to 8 or more. But typically speaking, it's about a week. So that the whole process takes, I usually tell clients, about 30 days, which is not terrible. And it amounts to about 1 month worth of rent, which is why I also counsel clients in eviction matters to file on the first on the first infraction, because if it turns out that they come clean and they fix everything, well, within that 30 days, if they've made everything good and they never do it again, well, you're fine. But if they don't, then you're going to see that same non-payment happen probably one more time while you're waiting for the process to be final. And so this limits the amount of lost rent that you're going to experience, because you can, from the day of filing, this doesn't even include your notice to vacate, from the date of filing, you can anticipate about 30 days in the process. Longer if they appeal, longer if some other issue comes up that creates delay. So it's important to know that at the very least it's a 30-day process, because the truth is, if they've dug their heels in and you're required to get a writ of possession, that could extend the process even longer, right? Because you got to wait the 30 days before you can even get the writ. And once you get it, is it automatic? Of course not, right? Here in Harris County, the average wait time is about 2 to 3 weeks for the writ of possession to be delivered and then subsequently enforced. So what does that come out to? We're talking about 45 days from the date of filing to the date of possession for somebody who digs their heels in. Now, that's for somebody who didn't appeal. If they appeal, the timetable is much longer. And so if we're just talking about your initial eviction filing, from start to finish, from filing to forcing someone out with a writ of possession, typically it's about a 45-day waiting period. And so it's important to know these times, because nothing is quick and nothing is automatic. And so knowing this helps you make hopefully a more informed decision in how you ultimately resolve, even by some kind of settlement, resolve the issue of possession in your eviction matter. All right, have a good one. So send me your questions. If you've got questions about landlord-tenant law and there's something you're a little shaky on or something you just need a little clarification, post something in our Facebook group. Shoot me an email at ernie.garcia@attorneyeg.com. It's right there. Or post something in our Facebook group. If you're not a member yet, join our Facebook group. We look forward to you. If you look on Facebook, we are Texas Landlords. Finally, if you want to call, that's our number. Feel free to call us, and we'll be happy to help in any way that we can. And so keep your questions coming. I'm happy to answer as many questions as I can.